All right.
Good afternoon. Bart Rockenbach on behalf of Hensley Chalfant. Thomas Flanagan was injured. He suffered a traumatic brain injury as a result of an accident. He and his wife, Eliza, hired an attorney named Anthony Grenice, or Grenice, I'm not sure which one it is, but he hired Mr. Grenice to represent them in a personal injury claim. Mr. Grenice put together a pre-suit mediation with two people he identified as potential defendants. And at that mediation, they came to a settlement agreement for $1.55 million. About 24 hours later, Eliza Flanagan began to realize that the amount of money they had just agreed to was not enough to take care of Thomas's injuries, that his injuries were very bad. Mr. Grenice had done no investigation. He had no experts. No one ever examined Thomas. He didn't know what was wrong with him, really. And so Eliza hired or went to see Jeffrey Hensley at Hensley Chalfant to see what can be done about it. Mr. Chalfant told her that he would look into it. He ended up hiring a couple of doctors to examine Thomas Flanagan, and their conclusion was that he had a traumatic brain injury, that he was mentally incompetent and could not make decisions on his own behalf. That did two things. That meant that the settlement that he had entered into previously was voidable, and the second was that Mr. Hensley needed to get a guardian appointed, which he did. Court declared Thomas to be incompetent, appointed a guardian, Ms. Carpenter. Ms. Carpenter's first act was to hire Mr. Hensley to prosecute the personal injury action. To do that, she signed a contract. The contract said that Hensley Chalfant would be paid a percentage, 40 or 30%, according to the Supreme Court sliding scale, but they would be paid a percentage based on the gross recovery. That contract contained no indication, no mention, no words, phrases, or even innuendo that there would be some sort of holdback or limitation on that, and that the first settlement that was voidable would somehow act as a floor for Mr. Hensley. Mr. Hensley filed a lawsuit, and the defendants, Diamond Built and Sunlight, they filed their own lawsuit seeking to enforce the settlement. That particular enforcement action went on for 2 to 3 years. It was never resolved. But it is our position that because the contract was voidable, that settlement agreement was voidable, that it was automatically voided when, number one, Mr. Hensley wrote a letter saying that he was not going to go through with it. Number two, filed a lawsuit against the defendants and eventually a third defendant. And then number three, when they refused to sign the release and go through with the settlement. There were multiple ways that the defendants were put on notice that Mr. Flanagan was incompetent and that he was voiding that contract. Mr. Hensley handled the case for a little over a year, added a defendant, and ended up settling the case for $2.5 million. The settlement came in pieces. The first was Diamond Built. When Diamond Built settlement came through, it was for $900,000. And Ms. Carpenter, the guardian, she agreed and put in the petition that Mr. Hensley was entitled to $360,000 of an attorney fee, his contingency amount, for this portion of the case, talking about just the Diamond Built settlement. There were two other settlements then. The J.C. Carpets, I think, came up with $250,000, and then Sunlight came up with another sum to add up to $2.5 million, $1.99 million of which was apportioned to Thomas as opposed to Eliza. After the first petition was filed, there was only a $100,000 payment to Hensley Chalfant. The rest was going to be held in escrow, waiting to see what Mr. Grenice wanted as far as his quantum merit fee. Mr. Grenise's quantum merit fee was eventually resolved for $37,000, I believe, maybe $38,000. It was an insignificant amount of money. But it was eventually resolved, and then the other settlements came through, and at that point, there was a dispute. It turned out that that Ms. Carpenter and the lawyer that she had hired had come up with a new theory that Mr. Hensley was only entitled to a fee on the incremental increase that he obtained over the first settlement. Their position was that that first settlement that Mr. Grenise obtained was always there in the background. They could have always accepted it. We believe, and I think the case law we've cited supports the fact that, number one, it was voided by it's a unilateral voiding that they are allowed to do because he was incompetent. Being incompetent by either age or mental status.
Can I ask you a question?
Yes.
I think you mentioned there was no set-off in the fee agreement with the attorney you represent, correct?
In the fee agreement, there was not. Later on, Mr. Hensley said that he would go ahead and pay whatever it is that Mr. Grenise was owed. Out of his portion, right. The law did not require him to do that.
But Grenise's involvement was known at the time of the contract with this?
Yes.
Okay.
Yes.
Was there anything affirmatively saying that it would not be taken into account when calculating the ultimate fee?
That what would not be? You said it.
The Grenise's involvement, or the
no,
1.55 million would be exempt from the fees.
No, there was nothing in the contract that said that.
Either way.
Either way.
So the court was confronted with the factual determination at the tail end. What's the fair measure of fees in this case?
Yes.
I mean, your interpretation of the contract, their interpretation says it's still subject to the court's discretion as to what's equitable.
Well, yes, that's their position now.
Okay.
During the entire litigation, though, that was not the interpretation. Okay. You know, that original settlement could not still exist. It couldn't exist by operation of law or fact. And I want to pose to you this possibility, and this is heavily relied on by the appellee, the idea that even if they lost the case, let's say that Mr.
There was a motion to enforce, so you mentioned that.
Motion to enforce, and it sat out there. That's not really in the record. I just know that it existed and it was never resolved. Okay. All right. If the defendants in that case, that enforcement action, if they knew they could get out of the case for the 1.55 and enforce it, it would have been done.
They tried, though.
They filed a lawsuit. But there's no motion for summary.
That counts as trying in my book.
Yeah, there's no motion for summary judgment. They didn't pursue it. No, they didn't actually try to make it happen.
Shifted their efforts to the defense of the
right
Hensley lawsuit.
And in the end, the enforcement action died not because it was settled, but because the personal injury case was settled.
Right.
All right. So I want to go down this rabbit trail, this idea that if Mr. Hensley had prosecuted the entire case, and at the end of the case, let's say that something bad happened during the litigation discovery. The one I thought up was, what if there was a co-employee that was deposed, and in his deposition he revealed that Mr. Flanagan had been drinking alcoholic beverages before he fell. Well, at that point the case would be worthless. The jury would probably award nothing, and a defense verdict. The appellee's position is that they could have then just turned around and gone to the defendants in the enforcement action and say, okay, never mind, we'll go ahead and accept your $1.55 million. That would require that they basically admit that their pleadings in that case, the position, and this is described in our record, their position that Mr. Flanagan was traumatically brain injured and had no capacity to contract, that their position was a fraud, that they were lying the entire time, and that they now wanted to reverse everything and say that they want to accept that settlement, even though it would be contrary to their position for the last 3 years. There is no basis in law or fact for that. The trial court decided that...
It's like they're trying to add a term into the the contract that isn't there.
Yes. They are trying to add a floor, I'll call it a floor, to the contract, that Mr. Hensley only gets paid if he gets something incremental. But, you know, that wasn't something that's in the contract. Mr. Hensley, I think he testified that he wouldn't take the case if that was the rule.
They could have negotiated that, but they didn't.
They could have, and they didn't.
But the court decided on a procuring cause basis.
Yes.
Which wasn't in the contract, but that's presumed to be part of the contract.
Well,
As a condition to earning your fee, you have to be the
Right.
procuring cause.
well, first, I would dispute that the term procuring cause has any place in a fee dispute, in a fee situation like this. Certainly not one where there's only one lawyer. The case that they rely on is the Perez versus George Hartzlandine decision, where the court talked about procuring cause. But there were two attorneys. One represented.
That's the two attorneys.
There were
right?
two attorneys, right?
And this is between the client
Right.
and the attorney.
Right.
This isn't the two attorneys.
There's only one attorney
arguing
here.
over who gets what.
Right.
It's the client saying, we're not going to pay you as much.
We're not going to pay you as much as you
First
thought you were going to be
attorney
paid.
is not seeking beyond the
Right.
30-something
Right.
thousand that he was already paid.
I missed.
He's not going to the client for more,
No.
whether he comes to Hensley for more is not a matter before us.
No, and he's not coming to Hensley for more. He's been paid his quantum merit fee.
Right.
So, the procuring cause, if you have two lawyers in the George Hartzlandine case, one lawyer, Mr. Allen, I think, he did nothing on the case. Nothing. That's the father's lawyer. He sat in his office, didn't come to mediation, did no work. George Hartzlandine, they did all the work and ended up getting the settlement, and it happens to benefit the lawyer who's doing nothing's client. That's the father of this deceased child. And the court said that all that lawyer gets is quantum merit because he didn't do any work. And they used procuring cause to describe the idea that he didn't earn his
Well, I
fee.
mean, that makes some sense between the two lawyers, but I'm struggling with how
It doesn't apply
makes any
here.
sense here.
Right. Our position is that it can't apply here because these clients had one lawyer handling this case. The only procuring cause for the $2.5 million settlement was Jeff Hensley. No one else could have done it. It's not like a sales, that's where procuring cause comes from, is a sales agreement
Real estate.
where, I'm trying to sell this place and all of a sudden it gets sold, but it's sold by somebody else. Nobody can interlope in an attorney-client relationship. Third parties can't just jump in and say, hey, I've settled that case for you and your lawyer didn't do any work on it. That doesn't happen. So the trial court based the conclusion that Mr. Hensley was entitled only to the increment on a proposition that doesn't apply. And then the trial court also just ignored the terms of the contract. The contract says you get a percentage of the gross recovery. That's it. So based on the contract and based on the law, Mr. Hensley was entitled to his entire fee. Part of what bothered the trial court was the idea that the clients can't be forced to pay more than what a single lawyer would be allowed to get. But there are cases, Rosenberg versus Levine and Adams, there's one more, I can't remember it right now, it's in the brief though. Those cases say that a client is allowed to hire one attorney, fire that attorney, and owe that person a quantum merit fee, hire another lawyer, and pay that lawyer the full contingency, 40, 30, 20, on whatever the recovery is, and then also pay the first lawyer. That gives they talk about a balancing. That balances the client's right to choose which attorney handles the case, but it also makes the client responsible for the client's decisions. Here, the client is getting a windfall, basically. They're saying that they duped Mr. Hensley into representing them, and they, the whole time, they never intended to pay him on the gross recovery. They really intended to pay him only on the increment, and at the end of the case, after Mr. Hensley had put in $30,000 of his own money into the case, that's when they tell him that, no, Jeff, that's not right. You only get that little bit. What if Mr. Hensley had taken the case and got $1.55 million. They're right back to square one. Today, they would be saying, you don't get any fee, you took a risk. You know, if the case had come in at $500,000, I'm pretty sure there might be a malpractice suit that would be levied against or brought against Mr. Hensley for messing the case up. The clients would say, we used to have $1.55 million in our pockets from that first settlement, and now we have 500. The loss of that $1 million is your fault, and now you have to pay it. So he's taking a lot of risk. He's taking a risk that the clients get nothing. The clients voluntarily took that risk. But now, at the end of the case, they want to change how the money is distributed.
And they are getting under this arrangement, 1.5 million without paying a fee on it.
They're getting $1.5 million with paying only $37,000 fee. Right. I don't know how much
You're down
time
to
they
about 5 minutes. And
Well,
so
that's
you
great
can
then. I'll take that.
Save them.
Very valid.
There
Thank
you
you.
go.
May it please the court, my name is Richard Pierce. I'm here on behalf of the guardianship of Mr. Flanagan. Not surprisingly, we take a very different view of the situation here. Our analysis began with the question of whether the application of the contract with Mr. Hensley in these limited circumstances resulted in a clearly excessive fee, because he would wind up collecting a contingent fee on a matter that was no longer contingent, because it was the subject of a written and consummated settlement agreement. The settlement agreement obtained by Mr. Grenice was reduced to writing. It was signed by all parties, including Mr. Flanagan. It was signed on April 15th, 2009.
I mean, that's all prior to the guardianship being established.
Yes. And so...
And we don't know if he was competent at the time he signed it. We only know he was incompetent when they established the guardianship.
And that, the first, the magistrate's findings of incapacity didn't come down until July. The appellants only addressed that question by focusing on the general magistrate's findings, which were the result of a hearing that took place a couple of months later. And even then, they only focus on a provision of that order which says that Mr. Flanagan did not execute a power of attorney that contained a healthcare surrogate provision, which in point of fact is correct. He had signed a power of attorney, but it didn't contain a healthcare provision. That judgment of incapacity did not address his status on April the 15th, 2009, when he signed the agreement. It didn't address any issue of how far back his incapacity may have extended. It provided a determination of incapacity on the date that the hearing took place, and that the general magistrate's findings, which were eventually adopted by the court, were made. And so what we have here is a presumptively valid settlement agreement, signed by Thomas Flanagan, signed by Eliza Flanagan, signed by the two defendants,
But
Diamond
it's
Bill
one
and Sunlight.
they wanted out of.
They didn't want out of it. It's the Flanagans who wanted out of it.
Well, that's what she's saying.
Okay.
They
Yeah.
wanted out of it.
Well,
They wanted out.
yes.
They wanted more, and he got it for them.
But to get more, he basically has to repudiate that first settlement, correct?
Well, the problem with the analysis, I think, is that the appellants take the position that simply by an act of repudiation, that agreement somehow goes away. But the fact is, there's no evidence in the record that shows it was even voidable, and that the evidence of its voidability, or that it was actually rescinded, was never presented to any judge at any time. Certainly, Diamond Bill and Sunlight didn't agree that the agreement was rescinded.
No, but they paid more.
They paid more,
Well, they
or
filed
could've
a
gone to
lawsuit
trial.
they filed a lawsuit to enforce the
But they
agreement.
ultimately paid more,
They ultimately settled for more,
right?
taking into account the risk of having, of going to trial.
I mean, is your main argument that the court properly exercises discretion in finding this was an excess fee?
As a clearly excessive
I
fee,
mean,
yes.
That's the sole basis.
Rule 4-1.5.
Okay, that's cool. So then my question is, let's rewind the situation. I'm Chalfant, Grenice, I know he's involved. I say, listen, Grenice, I'll buy out your interest in the settlement. I'm taking over the case. What's it gonna cost? You say, you know what? I'm probably entitled to a third of that 1.55, but I'll take 37,000. He says, I'll give you the 37,000. I'll pay you at settlement 37,000 out of the entire fee, whatever we get, whether it's 1.55 or 3.10. Would we, and then case goes the way it did, would we still have an excess fee argument here?
Well, in point of fact,
The fact is they dealt with it on the tail end instead of the front end.
well, and
Should
in,
that change the outcome?
and in point of fact, the record establishes that Grenice's fee contract did not conform with Rule 4-1.5.
So it might have been unenforceable.
And so it was unenforceable. That's how come he
Okay,
settled
so you're
for
saying,
the,
though-
for the quantum merit.
You're saying, though, that, on your client's side of the equitable ledger, they are entitled to basically $1.5 million without paying a fee for it.
Well,
That's the remedy.
well, in this case, that was a completed settlement. And
Yeah, I
but,
know,
and
then
but, and,
they haven't had to pay a fee, an
Well,
attorney's fee for it.
but Grenice's fee contract was invalid. And they would receive the benefit of the invalidity of his contract. He would have the right.
They would have
then to-
received that benefit regardless, is what you're saying, because
Yeah.
Grenice's fee agreement didn't comport with the rules, and he was limited to quantum merit, and the
and-
37,000 was actually quantum merit, not an agreed-upon settlement. Is that what I'm hearing?
Well, it was, the court, he intervened in the enforcement case. And the court, the judge in the enforcement case ultimately ruled that his contingent fee contract was unenforceable because the percentages specified exceeded the bar limits. And so he was stuck with quantum merit, and then there was a settlement in terms of the amount of the quantum merit.
I got you. Okay.
But the question is, does the invalidity of Grenice's contingent fee contract redound to the benefit of Mr. Hensley? Mr. Grenice had a completed settlement agreement, which the two defendants were suing to enforce. You know, Mr. Hensley admitted in his deposition, which was admitted in evidence, that his legal
So
services.
he would have gotten paid regardless of when the case was settled. If it came down to quantum merit, he could have came in after the second settlement, so to speak, which is what he ended up doing, right? He didn't get paid till the very end of this case.
Mr.
Grenice.
Grenice. Mr. Grenice, after he was discharged, and after Diamond Build and Sunlight filed their enforcement action, he moved to intervene in that enforcement action, seeking to enforce the original settlement agreement. And it was in that context that his contingent fee contract was discovered and determined by the judge in that case to be invalid,
Right.
leaving him with only quantum merit as a remedy. But the question is, having completed the first leg of the settlement, who gets the benefit of the invalidity of Mr. Grenice's contract? Does Mr. Hensley, who admitted in his deposition that none of his legal services contributed to that settlement agreement? You know, the problem here is that you've got a completed settlement agreement, so as to the 1.55, there's no longer a contingency. And yet, Mr. Hensley's demanding that he be paid a contingency on something that's no longer contingent. That agreement was never determined by a court to be invalid. It was never determined by a court to have been lawfully rescinded. You know, it's our position, rescission can happen in one of two ways. The parties can agree to rescind and put themselves back in the position that they were in prior to the initiation or prior to the contract. Or rescission can be brought about by a judicial remedy.
So really, the way you're explaining it, there's really no windfall to determine who gets the windfall. it's a matter of Grenice lost out because he had an inadequate contingency fee agreement.
Right, that's exactly
Otherwise,
right.
he'd be coming in for his full share, which
That-
is what he obviously sought to do in the first case.
That's exactly right.
And then we have an argument, would this be an excess of settlement? Does it have to be an excess of settlement to get the money paid to two lawyers, the same money paid out twice? And clearly that's excessive, but that never happened because Grenice's fee agreement was inadequate.
That's correct.
You know, it just seems really odd to me that your clients can disavow the settlement, walk away from it, and then turn around and take the position that, oh, well, that wasn't contingent anymore because we had a settlement. You know, you're taking inconsistent positions.
Well, I think that there's a difference between the contract and the rule which requires as a matter of public policy that lawyers not charge clearly excessive fees. The lower tribunal found
Well, it's a Florida bar approved contract, right?
yes, ma'am, but even a Florida bar,
With the approved contingent fee.
but, well,
So how is it clearly excessive?
well, first of all, as Mr. Sasso, who was the expert witness for the guardianship, testified, Rule 4-1.5, as it relates to contingent fees, sets an upper limit, but it isn't necessarily conclusive.
But that's not as I understand it, your position and what the trial court found is that it was excessive because it was based on the entire amount of the settlement as opposed to just a portion. So it wasn't the percentage that was the problem.
That is correct. The problem
Okay, so
was,
let's talk about what we have here then.
okay, the problem was that Mr. Hensley was trying to collect a fee on a
On
completed,
the entire settlement.
well, on a portion of the settlement that was already completed, that was no
Yeah, but
longer
you know,
contingent.
You keep saying it was already completed, but you all walked away with it and you were dissatisfied with it, and I'm certain that if the defendants had continued to pursue enforcing it, you would have fought it vigorously and tried to get that settlement set aside. But now it's really convenient, now that it's all said and done, to say, oh, well, you know, that settlement was a done deal, that wasn't contingent anymore.
Well, the fact is that there was a signed contract. The fact is that the matters were all settled without ever there being an adjudication that in fact that contract was ever avoided. There was no evidence presented in any courtroom that I'm aware of that fact. There was no determination made by any judge that Mr. Flanagan.
But we do know your clients walked away from it.
Well, yeah.
That we know.
Mr. Hensley notified the two defendants that they were not going to
Right.
complete the settlement agreement.
Right.
That's correct.
And he was authorized to do that by your clients, correct?
We know he was authorized to do that by Eliza. I don't know what the,
Well, you're not contesting his authority to do that.
I did not raise that issue.
Okay.
I did not raise that issue.
Wasn't that why they hired him? They wanted him to make that go away and get more money?
Well, certainly the evidence was that Eliza was dissatisfied with the settlement. But as the trial court found, you know, matters got settled without there ever being a determination that that agreement had actually been avoided. I mean, rescission requires proof of a number of different elements. It requires proof.
Yeah, I understand all that.
Okay.
But my point is, who cares? Because what we do know, I mean, why is that legally relevant?
Well, because if the contract was never rescinded, you know, the cases that they're relying on where there are serial counsel typically involve the first lawyer being terminated, fired, after an offer is made but not accepted, and the second lawyer coming in, and as long as the contingency isn't met, then there's
No, I understand what you're saying. I understand that distinction.
But in this case, the offer was accepted. And even though there was an attempt at repudiation, we really don't know if what Mr. Hensley communicated was an offer to mutually rescind. We don't know that the contract was even voidable. You know, we don't know what the outcome of all that would be because it was never adjudicated anywhere. So that contract was still out there. Mr. Hensley, in his deposition, admitted that none of his work resulted in that settlement. He admitted that, either in his deposition or at the trial, that if...
I guess maybe the bottom line question for me is, why is that prior settlement legally relevant at all?
Because it was a completed contract, and therefore, as to the $1.55 million, it was no longer contingent. I mean, for the Flanagans to receive the $1.55 million, I mean, they were being sued by these two defendants to take that money. All they had to do was nothing. All Mr. Hensley had to do to get that was nothing.
That they couldn't get
Right,
any more.
that they couldn't get more.
And the whole reason they hired Mr. Hensley was to get more than the 1.55.
And he got more, and he certainly is well deserving of a contingent fee on that portion of it. But for him to collect a contingent fee on a matter that was no longer contingent, that was procured by...
So nobody gets a fee on the original $1.55 million. They
Not a
just
con-
get
not a
that
con-
without the benefit of paying a fee.
Well, they don't get a contingent fee.
Well, Grenice got
Grenice got a
Quantum
fee.
Merowith,
Grenice got Quantum Merowith.
which he would have gotten with a improper fee agreement.
Correct.
But that was paid by Hensley, wasn't it?
No, that was
Out of
paid
his
by the
portion of
guardianship.
the proceeds?
No, ma'am, that was paid by the
I
guardianship.
thought that's what it said.
No, Mr. Hensley offered to pay it. It was, in effect, a verbal modification of his fee agreement, which would not have been enforceable under the rule. But certainly, under the outcome of this case, it would have been inequitable for him to have paid the Quantum Merowith fee, and so it was paid by the guardianship. So, in sum, basically what we have here is a completed settlement as the first $1.55 million, which means that Mr. Hensley, under the Perez case, under the Florida Bar versus Rude case, under the Morabur case, those are the principal cases on which we're relying. They basically say that the fees you receive have to be proportional to the work that you do. We have a completed settlement procured by Mr. Grenice. The fact that his contingent fee contract failed him because it was invalid doesn't redound to Mr. Hensley's benefit. If it redounds to anybody's benefit, it should redound to Mr. Flanagan's benefit, since he's the injured party here. And clearly, from an equitable standpoint, is clearly in need of money. And I hasten to point out that Mr. Hensley received a substantial fee for his work. He received and has been paid $304,000 on account of his work. So we believe that Judge St. Arnold made the correct decision, and we ask this court to affirm. If there are no more questions, then I'll sit down.
Okay. Thank you, Mr. Pierce.
Just a couple of things, and then I'd like to get in my car and drive back to West Palm Beach.
Okay.
I hear Mr. Pierce keep saying that it was, and I wrote it down, I hope verbatim, it was a completed contract, and as to the 1.55, it was no longer contingent. In this business, a contingency has occurred when the check has cleared. Up until then, it's contingent. Nobody can say that they couldn't spend that money. The money was not in an escrow account. There was no agreement with the defendants that we will take your $1.55 million and then sue you for more, and the defendants are okay with that. They offered $1.55 million to get a release, have the case be over. That is when the contingency occurs. Mr. Pierce has cited no case where the contingency has occurred prior to the settlement being completed. They don't exist. because that situation cannot exist. As for whether Mr. Flanagan was found to be incompetent at the time he made the settlement, both of the physicians, or one's a PhD, one is an MD, Williams and Frank, both of them, in their affidavits that were submitted in the incompetency hearing, they both found that his traumatic brain injury and his incompetency started on the day of the accident. So there was evidence, there was an adjudication that Mr. Flanagan was mentally incompetent and incapable of entering into a contract. That makes it voidable, unilaterally voidable. They rescinded the contract by letter and by filing a lawsuit. That contingency is not in the bag. It's not a done deal, and it's not a completed contract. It was just one more thing that didn't happen, and Mr. Hensley had to make the entire case work and get $2.5 million for these people. He did an admirable job, did an excellent job. He did all the work Mr. Grenice was supposed to do, hiring experts and finding out what the mental and physical condition of Mr. Flanagan was. And he did exactly what the clients asked him to do, every step of the way. And for that, he has been rewarded by a fee dispute telling him that he's not really entitled to what the contract says. And he is entitled to what the contract gives him. Thank you.
Thank you both. The court is adjourned. Have a safe drive.
You are all very generous with your time. You know, I had an oral argument yesterday on the 4th, got 10 minutes. I have to speak like an auctioneer.
Yeah, we do things a little different
We
here
listen
in a
slower.
second
You
piece.
listen
Yeah.
I won't tell them that.